Welcome to our session on mandatory mediation and local authorities. Thank you very much for your patience for a couple of minutes while we just got everything in order. I would like to welcome you all and introduce the panel that we've got for you this evening. I am Sophie Miles. I'm a barrister at Doughty Street Chambers, and I'm a civil and commercial mediator, and I'm also a community mediator undertaking neighbourhood and other types of community mediations with calm mediation. I'm very pleased that we've got a guest speaker this evening who is Geoffrey Milton. Geoffrey is the founder and director of an organisation called All About People, which offers tailored services, including conflict management, coaching, mediation for business, and in particular, HR, organisational change support, and workplace mediation. Geoffrey's got 25 years of experience in workplace mediation and is dedicated to transforming workplace conflicts into opportunities for growth. He's also a member of the Civil Mediation Council, and he sits on the Workplace Mediation Working Group. Dominic is also a mediator at Doughty Street Chambers. He's also a housing specialist who also practices in court of protection and community care. He's listed in both the Legal 500 and Chambers and Partners as a leading junior in social housing, and this year he was shortlisted for Legal 500's Property and Housing Junior of the Year Award. So that's the panel. Just a couple of housekeeping points. Please, if you have any questions during the presentations, do feel free to put them in the chat. However, we are going to allow some time at the end for questions. And if you raise your hand, if you would like to ask a question, we can then unmute you. The other thing to say is that we are going to record this session so that if anyone really wants to listen to it again, you can do so. I'm going to start briefly and speak about the kind of legal landscape for mediation at the moment. Before I do that, we're going to launch our poll. And the question is very simple. And have you ever used mediation and on one of your cases? So if people could just start sending in your answers, and we will see how it's what the eventual answer is. Right. And at present, right, so it looks like, well, it's still going, but more than half of you have used mediation in one of your cases. So we'll keep an eye on that. So if I can have the first slide, please, Ray. And I'm going to end the poll now. So just a little bit about the benefits of mediation. You know, can it reach the parts that the courts can't reach? It can save costs and time. It can help find a more comprehensive and imaginative and potentially commercial solution and reduce stress, and sometimes can be very effective in ensuring a sustainable agreement. But what about if it starts to become compulsory? Will that increase take-up? Will it remove arguments about whether to mediate? Potentially protect lawyers from concerns that it seems a bit weak if you offer mediation? Could it prevent lawyers from blocking mediation for financial gain? And it can we also find that even reluctant parties can warm up a bit in the course of mediation? So those are the sort of arguments about increasing compulsion. And we're really sort of moving into that zone at the moment within the civil justice system. So we'll find out in a moment a little bit about how that's happened. Ray, can we go on to the next slide, please? Thank you. So this is the sort of story so far, which just shows how over the last few years, it's been a gradual move towards embedding mediation into the civil justice process. So we start off in June 2021 with a report from the Civil Justice Council on compulsory alternative dispute resolution processes. And that says that as long as a form of compulsory ADR is not disproportionately onerous and doesn't foreclose the party's access to the court, then that it is still compatible with Article 6 of the European Convention on Human Rights. So that's the argument from the point of view of the Civil Justice Council. And then not long after that, in November 2023, we have the landmark case in the Court of Appeal, Churchill and Merthyr Tydfil, a knotweed case, where the question was whether Mr. Churchill's knotweed claim could be stayed because he hadn't used the council's complaints policy. And the lead judgment was from Sir Geoffrey Voss, Master of the Rolls, who has been a real advocate for mediation and for increased use of mediation. And he said, well, yes, absolutely. As long as using an alternative process doesn't interfere with the very essence of a right to a free trial and is proportionate, it's perfectly acceptable for the court to stay a case pending another form of resolution. Can we have the next slide, please? And so in May 2024, Genee World case, the district judge directs the parties to consider mediation. The claimant offered mediation at quite a late stage by letter and didn't really chase it up. The defendant didn't respond. But the court said that silence in the face of an invitation to mediate as a general rule is of itself unreasonable and increased the defendant's cost liability by 5%. So we've got some sort of muscle flexing going on here. Still in the same month, the small claims pilot scheme starts. That's running until May 2026, where attending a mediation becomes an integrated required step if you're trying to resolve a money dispute under £10,000. And that mediation takes the form of a free 1-hour telephone service, which takes place within a few weeks after filing a defence. So that's 2024. And then if we can go on to the next slide, Ray, we'll see again, really the big change in October 24 with the changes to the civil procedure rules coming into force. And the key provisions you can see on the slide, overriding objective enables the court to deal with cases justly and at proportionate costs, which obviously we know is going to be familiar to all of you, but that includes ordering or encouraging the parties to use ADR. And the costs provisions have also changed, where the court's considering costs. The conduct of the parties includes whether a party failed to comply with an order for alternative dispute resolution or whether they unreasonably failed to engage in alternative dispute resolution. So that's a really big change to the kind of overarching court rules that will be governing any kind of civil claim. And we're just going to look at a couple of cases where the courts have started to use these powers. So the first case I wanted to quickly look at from November of last year, DKH and others and City Football Group, and that's actually DKH is actually the clothing retailer Superdry, and the football group is Manchester City Football Club. And the parties had been litigating this for some time. They were close to trial. There was a pre-trial review, and the claimant asked the judge to direct a compulsory mediation, a short, sharp mediation, shortly before the trial. And the defendant said, well, what's the point? We've been fighting this for ages. We've spent hundreds of thousands of pounds. What we want is a determination. It's too late to mediate. The judge was not having any of that and said really clearly sort of three things that are actually, I think, very important. First, that mediation is capable of cracking even the hardest nuts, he said. The process sometimes succeeds in cases where the parties seem to have intractable differences. That it can bring the parties together and overcome an entrenched reluctance. And then I think really importantly, he said that mediation can go beyond the binary answer that a court can provide. there may be solutions other than yes or no. And I think that's one of the sort of crucial things that, to remember if you're considering mediation, that it enables you to move away from a straightforward, I've won, you've lost approach to the case. So the last case I want to look at, if we just go on to the next slide again, is a very recent case, and this was a chancery case, an argument about who should be the executor of an estate. Julian Fernandez had been the executor, and he'd been asked to mediate. He refused 26 possible dates for mediation. He failed to answer correspondence about it over a 10-week period. The judge held that his behaviour in frustrating the mediation purpose justifies a cost sanction, and in fact, he was ordered to pay indemnity costs. So again, just looking across the piece, we can see the court starting to really use these powers to push for mediation and to sanction parties who refuse. And if I can just go over to the last slide here. So where are we now? So mediation is now integrated across civil proceedings. It is worth having a look at the Superdry case just because of the arguments that are being made. And those are arguments that I think will probably be deployed quite widely. And I think the comments that he makes are also going to be kind of quoted quite widely. Certainly from our experience here, we're already mediating cases where the courts have directed the parties to mediate. And I think the lesson is, be proactive. There's nothing to lose in asking for mediation. We're particularly looking at local authorities for the purpose of this webinar, and I do want to draw attention to some of the many neighbourhood mediation schemes that are available at the moment. The charity that I work, Calm Mediation, offers neighbourhood mediation, and in fact has also started providing mediation training for frontline housing workers. So that's perhaps something to be thinking about as well, because obviously mediation is available once you get into litigation, but it's also possible to use mediation before you've even got to that point. And with that in mind, I'm going to hand over to Jeffrey, who's going to tell us more about how mediation works, and in particular in the context of workplace disputes, which obviously is his specialism. So before I do that, you've got a few moments to scan the QR code if you want. But other than that, we'll hand over, please, to Jeffrey's slides. Thank you all very much indeed.
Thanks very much, Sophie. Well, good afternoon, good evening to everybody. Could you go on to the next slide, please, Ray? So the purpose of this short session is to remind some of you who are aware of mediation a little bit about some of the models and examples of how mediation can be used, and as an alternative way, which is what Sophie has been talking about. So let's have a look at the next slide, please. And the next one. So here is a definition of some ways in which mediation can work for you. And you'll see at the top of the slide, I've put that mediation can take many forms of dispute resolution. Sometimes it's the civil and commercial stuff, which a lot of you may be talking about. It could be family. It could be the community mediation that Sophie is talking about with Calm, and which I'm involved with myself. And one that's quite a hot topic at the moment is SEND mediation in terms of its application and legal position as far as local authorities are concerned. And I will talk a little bit more about it within the context of the workplace. So what it does is enable people to help resolve the differences themselves. And I often call it's a way of nipping things in the bud and stopping it get to court with these lawyers. And it's an opportunity for partners to own and manage those outcomes and drive them themselves. An important part about it, of course, is that it's confidential and impartial. And I think the example that Sophie gave about Fernandez there is that he was dragging his feet, but we need to make sure that people are motivated to want to get into mediation as a way of solving their problem. It's non-judgmental as far as the mediators are concerned, and it does reduce the risks of escalation and costs. And it's a process where there can be a conflict of interest and you have to manage that. And I think one of the things around it is the importance of ethical practice. So next slide, please, Ray. So when would you use it? Well, if we apply it to the context of the workplace, there are a lot of rules and regulations and policies in place. And I give an examples of the grievance policy or disciplinary policy. And you may see familiarities with that within taking legal action, say in civil and commercial cases. And what you have an opportunity to do with mediation is to take a deep breath, stand back from implementing things formally, and look at ways of solving those group and team or individual disputes. When colleagues, and that's my last point there, is when colleagues are reluctant to follow formal people processes and recognizes the benefits of an informal approach. Next slide, please, Ray. So very briefly here, and there's lots of material written about this. These are the 5 key stages of workplace mediation, and it also applies to other types of mediation as well. So stage 1 is that preparation where you're talking to both parties to find out what the issues are. And that would be done on an individual basis. And then explore that at stage 2, where there are the private meetings to go into a little bit more detail. And then when you're at the right point, and this is the beauty of mediation, it allows the mediator to develop a relationship with both parties and explore with them privately and in confidence that what they're saying to you will not go anywhere else. It will not be written down or recorded, but it's there to move the mediation on. And then you get to the point, the magic really, where you bring 2 people together who are in dispute because they are ready to have that conversation with each other. And you are mediating and facilitating that. And out comes all the issues that they have with each other. Stage 4 is the problem solving and finding ways to move forward. And again, unlike taking legal action, you are leaving the parties involved in control of the outcome. They are solving the problem, facilitated by you as a mediator, but you are not there to give them the answers. And then the final stage is an agreement and commitment, usually in writing and some sort of follow-up. So it's a very simple 5-stage process. Could you move on to the next slide, please? So at that joint meeting, which I mentioned on the last slide, it's uninterrupted time for each party. And then I've got 3 points there: position, interests, and needs. And it's a nice mnemonic. So the party believes this will solve their concern. For example, sometimes it's as simple as an apology or a change of role, or it can be acknowledging that wrong's been done. And then the interest moves the party away from the past to the present. Needs is recognizing and working on needs will help the parties move forward and be future focused. So you're giving them an amount of time to vent and say what their issues are to the other person with that uninterrupted time. But at some point you want to move forward. And that's where you find the mutually beneficial solution. Next slide, please. So you keep things moving. Future focus. We all love to moan about the past and things that have gone wrong. So you're looking at problem solving, ideas and options, and the mediator there will be helping to facilitate that. and agree what you can agree on. Low-hanging fruit, perhaps, or the easy things to get agreement on. And it's all about questioning and getting the parties to come up with those solutions. And has everything been covered? Is there anything else you want to say? And then usually there's an agreement in writing. Next slide, please. So I was thinking about what could I tell you about from my lots of experience of work case mediation. Well, there's this particular case where there were two members of staff who separately had rather uncomfortable experiences with their line manager over drinks following an internal training session. And the boss was at the bar and probably got through about a bottle of wine in the space of about 3/4 of an hour. So, and it was really just unpleasant questioning and language, nothing sexual or particularly untoward, just that they felt a bit uncomfortable. So they both separately reported this incident to their manager's boss. So the boss raised it with the manager, who was absolutely horrified and admitted to his poor behaviour and wanted to put things right. So the two members of staff could have raised a grievance. It could have gone to a disciplinary. However, the line manager, the senior boss, said, look, can we try and find a way of sorting this out? You're all fantastic at your job. Do we really want to go down a formal process? So the team managers had lost confidence in their manager and ability to work with him. So this was going to be a big ask. And that's where I got called in this case, not only to talk to the two team members who were upset with their boss, but their manager. So it was a three-way meeting with all of them in separate rooms, and had done my pre-work talking to all three of them to understand the situation. And eventually I got all three of them together in a room, and boy, was that a powerful outcome. And it avoided a disciplinary and grievance process, which would have bogged everybody down, and there would have been somebody in the organisation making judgments there. So one example of how it can be really powerful doing workplace mediation. Next slide, please, Ray. So if we put all those up, so as you can see in that example, it reduces the risk of damage and helps rebuild relationships. And one of the things I suggest is that organizations adopt an early resolution framework, which means they have to go to or encouraged to go to mediation or dispute resolution before they implement the grievance policy or the disciplinary policy. See the similarity to what Sophie's talking about? Similar thing. It puts parties at the whole heart of resolving their disputes and has a restorative justice principle to it, and mind nipping things in the bud. And believe it or not, 80 to 90% of mediations are resolved with a settlement. It's a proven approach. Next slide, please. So do you go internal or external? And there's some points here. Often internal HR are responsible for recruiting and overseeing the process. Now that one needs to be careful with to make sure people are neutral and independent. So there needs to be training and understanding how that fits into the organisation, and you need to get a diverse range of mediators. So, and it may be challenging in some instances to choose somebody who's really seen as independent. And sometimes, as the case is more complex, or it's perhaps with senior people, in external mediation is not the right approach. Next slide, please. So appointing a person responsible for managing and procuring external mediators is rather important. My experience is it's a distressed purchase. everybody wants them the next minute, the next day, to come in and handle stuff and get people out of the mess. And so it can be quite good to have a bank of people that you can go to or understand about how mediation works, so that it's not a surprise when suddenly you need to go to it. And particularly where there are high risk situations of not a successful outcome. So I can think of plenty of cases with chairmen and CEOs and so on, where it's been really important to get a good and positive outcome. Next slide, please. So you might want to think about promoting mediation in your organisation, looking at the contracts of employment and making sure there's an early resolution approach too, and get sponsorship from senior people. If you're using external mediators, there needs to be some sort of communication and understanding around that, and perhaps run some workshops and promote it as a development opportunity for employees. I think I would say on it, most people absolutely hate conflict and don't like to deal with it. So the whole area of conflict resolution, conflict management, coaching and so on is something that people can consider and take into all parts of their business and working life. Next slide, please. So for me, it's all about people and relationships. It's about how you get beyond that process and agree a way to go forward and work forward. We don't have to be personal friends. We need to have mutual respect and agreement to move forward. And that's the important bit, is respect, mutual agreement, and moving forward. Next slide. I think we're going to come to questions at the end. So that's it. That's me. Thank you very much. Over to you now, Dominic.
Thanks very much. Just a quick, I posted on the chat, just if anybody has any queries or issues they'd like raised, do feel free to post them on the chat. And obviously there's an opportunity to ask questions later as well. And you may have noticed we've set this up as a seminar where we can actually speak to each other rather than a webinar, and that's deliberately so as to generate some discussion. So please, and I note already that Anne Nugent from Bristol has picked up one of the big issues in the Bristol area, which is the use of internal complaint schemes, which is a really important topic, even if it doesn't quite have a resolution at the moment. So I'll definitely come to that. I don't have a slide on it, unfortunately. As soon as I saw the post, I kicked myself slightly, but I will definitely try and address it in discussion afterwards. So next slide, please. Given that my session is listed as observations, I better tell you where that comes from and a little bit of my experience. Just shortly, I am really a housing specialist. I do a lot of quarter protection as well, and a specialist in that area as well. Both areas lend themselves to settlement conferences, to mediations, to roundtable meetings where you get people together. And you can imagine those happen quite a lot. And obviously that includes representing people in mediations. As a mediator, I've been a mediator for 12 years, but I'd probably say that it's the last 5 years that I've been doing quite a bit of mediation work. And I'm obviously registered with the Civil Mediation Council. And one stat that is worth picking up on for some conversation just down the line a bit is the types of mediation that I do. Well, in theory, I can do anything. But as it happens, of course, it's the client that chooses me, or other clients, because they have to get together and do so, who choose me. And they invariably seem to be looking for the housing element of my practice, in that 70% of the mediations I do are housing related. I also volunteer. I think most mediators do, because it's a really useful way of seeing another part of the mediation world, with a community-based mediation charity. And like Sophie, the one that I am involved with, it is very much about housing providers trying to intervene with ASB cases and social behaviour cases. And it's a very different form of mediation to the one we're really talking about today, but it's a really useful one. I might touch on it a little bit later, like Sophie. Next slide, please. Just dealing with, I didn't want to go through 15 million anecdotes of housing-related cases that I dealt with, but I did want to touch on the breadth of the housing topics. You know, very often people will say, well, you know, how can you mediate possession? That really isn't the case. With disrepair, it's an obvious area. But the sort of mediations that I do tend to actually be multiple clients, block claims, where your things can be quite difficult, quite extensive, and where the figures are quite large. But I've also dealt with small claims, individuals, or other lesser claims with individuals as well. So disrepair does obviously lend itself to mediation very well, and I would say that most people most of those are very successful. Hoarder cases, deal with those quite a lot. And again, you're talking about possession and discrimination, not necessarily antisocial behaviour, but certainly issues, fire risks, things of that nature. And you're also looking at the third area of law, which is community care and social services. And that's very often about making sure that they're in the room as well. And those sorts of mediations can work really, really well in avoiding effectively putting vulnerable on the streets. Another duty having to be picked up by local authorities under the Care Act. And so they lend themselves as well to mediation. And social behaviour, you'd be surprised about that, given the entrenched ways most neighbours can approach issues about antisocial behaviour, given the vulnerabilities involved. But that works well. Discrimination claims obviously come into the antisocial behaviour stuff as well as other things. Squatter claims, multi-party squatter claims, you'd be surprised how many there are. And the allocation cases, it's public law, but allocations can often be something that works. It depends a little bit on the authorities and the nature of the stock that they have, and slightly related to that, a lot of the mediations you deal with do have discussions about the options of alternative accommodation as part of it. And then just some old-fashioned black letter law involved with property, constructive trust, proprietary stop or undue influence claims. They come in quite a bit as well. In terms of the mediator experience, I mentioned the sorts of statistics for my practice. And the sort of people you might be looking for to do a housing case, it is your choice. It does not need to be a housing expert. As I mentioned, personal experience suggests that the parties do like to have somebody who has housing experience. But my personal view, and I'm looking at Jeff and Sophie as examples here, it's really the mediator skills that matter, not necessarily their legal knowledge. And I would emphasize that quite a bit. It's their ability to work with the parties on the day, get what's needed, and to get a resolution. The legal knowledge can be useful, but I think the mediator skills are much, much more important. A personal view only, and I certainly don't mind doing housing cases. Indeed, I enjoy it. I'm still one of those people who loves housing, but I don't get stuck on that. It would be my thought on it. Next slide, please. Sophie's mentioned this. I don't want to go too much into it, but there is a trend amongst lots of local authorities, and I know just how many local authorities are here at the seminar. And ASB cases are ones which are ripe for early intervention, and I think a lot of social landlords have tried to address that. They can involve really vulnerable witnesses, really vulnerable defendants often. They can involve multiple disability issues. When they go to court, they are long trials, expert witnesses, extensive documentation if they're defended. And that is really expensive litigation. And not only that, if the case goes wrong from the local authority's point of view or from the social landlord's point of view, you have real entrenched antagonism between neighbours. So it's a continuing problem if that litigation results in, for instance, a suspended possession order. And just the sheer number of work hours put in antisocial behaviour cases by officers on the ground, it can be quite phenomenal. So unsurprisingly, social landlords are attempting to embed mediation early on, and you see that both in terms of training housing officers on the benefits of mediation and how to get people involved, on the housing social landlords contracting out, effectively block contracting, I think is the way of looking at it. For community mediation services for early resolution, they tend to be sort of 2-hour mediations and referrals made to specific organizations that are contracted. And then I would say that there certainly is a trend. I mean, it's anecdotal and always difficult to know for sure, but the trend seems to be going, if full mediation is needed in the context of litigation, that happens probably before witness statement, sometimes after disclosure, because very often the parties want to see exactly what the history says, but early on before the costs just spiral. Next slide, please. I wanted to just look at some of the common themes and common problems and also the way mediation works. And there is some repetition of what Jeff and Sophie have said, but I hope it's worthwhile. It's a perspective, really. If you look at the common problems that you get in mediation, and particularly in housing, where it's sort of, losing your home is a big thing, and moving somebody on for lack of rent arrears or whatever it might be, ASB is important. So you get very entrenched positions, and very often you get an absence of trust, personal animosities very often. You also get, really unrealistic expectations from lay clients who aren't advised, or sometimes people who do have legal representation, but that there hasn't really been any risk analysis undertaken. So the expectations can be difficult to manage, and very often you've got unknown hidden priorities or concerns. It could be that for a particular tenant, the aim is to move in with mother elsewhere so as to, or move closer to mother elsewhere so as to help with caring responsibilities. You don't get, that doesn't come out very often. And sometimes there's good reason for those things to be hidden, and mediation can really help with that. I think to make a mediation work, there'd be two big things I would say. The first is treat it like a case in the sense of prepare in advance. You should arrive at a mediation knowing what you want, and so what you're hoping to get and what you can live with, your bottom line. You should arrive understanding the risks and costs if litigation continues, really knowing what the benchmark is. And you should really have thought through the potential savings and opportunities of mediation. And Sophie talked about the opportunities, that those things that a court just can't give you, which you might be able to pull out in a mediation. And on the day, be aware that the process does take time. I would not expect most mediations to go beyond days. I have had 2 or 3 days mediations, but I've never really seen anything succeed if it's less than a day. And so I think 1 day at the very least is what you need. And that's because you need time for exploration, for working out where the potential common ground is, making each party understand what the other's position is in terms of what their needs are, so that you can try and work out where there's common ground. And even then, when you've done all that, and you get down to the bargaining, and you get down to, in the areas that you've identified, that can take time to resolve. And even then, when you've got a resolution, you then have to draft an agreement. And that can take time, because then you have to do the detail. I have never known a day, anything under a day work. And I've also noted that, certainly in my experience, you get very, very good results from my perspective, a result just means that the parties come to an agreement, but you get positive results with the right amount of time available. Next slide, please. So if you are a mediator, you will often, you've heard me talk about it, you've heard Jeff talk about this period of exploration. They're trying to work out the common themes, and you've heard Jeff talk about having open sessions and then maybe talking individually with a mediator. And what you're trying to work out is effectively the cost-benefit analysis, the relevant factors that might motivate one party or another. And I've just put some of the things here that people ought to be thinking about in housing cases and these sorts of things. Obviously, the financial costs of avoiding litigation, you need to know what your costs are and what they're going to be if you go to trial. But also there are other costs. There's the accountant's costs, the expert's costs. That might not be charged, but are still costs that you're incurring. And in that context, the time and resources saved, your time, legal time, management time, staff time, surveyor's time, all that time saved is particularly, it can be really important. I put here avoiding lost opportunities and gaining opportunities, and again that's touching on the point about things that you can get or things that you avoid losing that a judge might not be able to help you with. There's the benefit of enhancing and maintaining continuing relationships. We're talking about landlord and tenant mostly. That is usually a continuing relationship. It might be a termination of relationship, but it very often is continuation of relationship. And building goodwill to avoid future problems is really important. There's reputational risk for public bodies. I remember there was a case in Norfolk I had, 85-year-old apt causing the worst antisocial behavior you can imagine. And the judge just looked at the local authority and said, "You must be joking. I'm not putting an 85-year-old out on the streets." Notwithstanding that in any other case. And that reputational risk, that risk of that getting in the papers, was probably what was in the judge's mind, and maybe hadn't quite got to the local authorities' thought process. But there's also reputational risk for individuals. They don't want findings of facts against them. They don't want to have finding by a judge that can be used against them. And that can be a motive for settling. And don't forget the mental health issues, particularly with individuals on the other side. They can get very preoccupied with the case and they might really want that to stop. There can be stress for parties, but also for witnesses. You know, some witnesses really are terrified about giving evidence, and local authorities, social landlords will very often have that in mind. And then there's that inability to move on until the litigation is resolved. And again, that can be both parties and witnesses. Next slide, please. Just some thoughts about trying to create value. And this is, again, that's something you'd be thinking of in the exploration stage. It might be in the bargaining stage as well. Just economic benefits. It's an obvious one, but it really must be remembered. There is a big difference between paying, I don't know, £50,000 and paying £5,000 over 10 years. Structured time payments can make things work. We should also remember that in a possession case, you're dealing with, let's say it's a leaseholder property. In fact, I had a leaseholder property involved with massive disrepair. And in fact, the landlord said, "Well, I'll buy back the equity." That is not something the judge could have given. And the tenant was happy. "Okay, I'll give up my damages. I'll give up the property, but I'll take a cash payment." And then maybe all sorts of other money in kind situations. Would you like a new carpet instead of damages? That might not be something that a social landlord will want to give. But it sounds mad, but an extension for £20,000 instead of damages for 50 might be something that they go for. And the reason that they might go for it, it's an improvement on their property, which they will eventually get back. Personal benefits, these apology expressions of regret. I note that about 2/3 of you have all been involved in mediations. That is really important. Reputation, preservation of dignity, confidentiality can be an issue, particularly for social landlords. might also be opportunities for positive publicity, and preserving, enhancing ongoing relationships. On that one, that can sometimes be about, let's say it's a disrepair case, that can often be about somebody finding a surveyor that they like and wanting to keep that surveyor involved. Again, anecdotally, apologies for the anecdotes. I had a mediation started, opened, and I thought it was going to be an absolute disaster after 10 minutes because the tenants spent about 10, 15 minutes telling the local authority just how the lack of communication, people turning up and not doing things. We've all heard the stories. 15 minutes of diatribe. I say diatribe, 15 minutes of real complaint that was really in his heart. And I thought, there's no chance. And at the end, he turned to the surveyor and said, you've only been doing it for 6 months. And in that 6 months, it's been the best 6 months I've ever had. I'm so glad you're there. One thing I want out of this mediation is I want you to keep being the person I talk to. And it was just so important to him that it pretty much, at that point, you thought, right, it's all going to work. But it was the key to unlocking actually quite a difficult problem between two parties. So preserving relationships, or indeed giving somebody a new contact, can be really important in terms of creating value. Next slide, please. Just an example. I'm just conscious of time, so I'll try and run through it. But this is an example involving an electric scooter. Tenant needed the electric scooter, had disabilities, could only charge it, couldn't get it in the flat, could only charge it by parking outside the ground floor flat, parked in the communal space with the stairs, created chaos for everybody else living above them on the 2, 3, I think 4 floors above. And the landlord took possession proceedings very worried about fire risk. I.e., if there was a fire, people wouldn't be able to get by easily with an enormous scooter being charged at the bottom of the staircase, particularly if it was dark. And it got very heated. I mean, very, very heated between the parties, very entrenched positions. And the resolution came from the local authority, no, forgive me, social landlord in that case, looking at the possibility of building a secure shelter for the scooter with a charging point somewhere else. And this came up quite early on in the mediation. It was only a day's mediation, but I have to say it worked because the housing association got surveyors, planners on the phone, got them down to the area. There were videos of the area. They had maps going out. They had pictures of the area. Everybody was able to agree where it was going to go, work out whether or not it could be done. And by the end of the day, there was a signed agreement on that. So that wasn't my case, I have to say. That was a colleague who did that case. But a really good example of how a landlord who came absolutely prepared, had all the right, knew exactly who they needed to contact, and then something came up which looked like it would work, and they were able to use the time in the day getting information in, and that worked really, really well. And if you think about the added value for the two parties, well, from the tenant's point of view, might have had a discrimination claim, but no judge could leave the scooter in, causing a fire risk in the corridors, and no judge could order a shed to be built. So this was a solution that was completely outside what might have been possible in court. And from the landlord's point of view, the neighbours are happy, the tenant was happy, so good continuing relationship, real change, lower damages in exchange, and a continuing amenity. It's owned by the landlord. When this tenant moves on, it can be used for somebody else. And of course, avoiding the cost of litigation. Next slide, please. A bit of a recap, because of course, we are talking about the cost implications of not going to mediation. So I've talked about, why mediation would work, why it works in housing, my experience of it, but we need to just look at very quickly, just a reminder of why it is that it's going to happen that much more, and as Sophie said, is already happening. So obviously CPR 1.1F, dealing with the case justly, means promoting the use of ADR, and that means directions orders that have provisions. I've put up an example order. You'll be able to get the slides if they haven't already been sent out. Hopefully will be sent out soon. And that's the order that was in Northamber and Genee, which is one of the cases I think that Sophie referred to. And that's a good example. So effectively consider mediation, tell us why you've refused it, and that'll be something we consider on costs at the end of the trial. And we can see where that comes in at CPR 44.25, the cost sanction. The conduct of the parties includes whether a party failed to comply with an order for ADR. Forgive me, Sophie, for repeating that. And obviously that first bit relates to the order I've just put in there. But there's also potential cost sanction if a party unreasonably failed to engage in ADR, whether or not it has been ordered. So if the court hasn't mandated mediation, ADR can still be relevant. You or the other party can put the other party at risk of alternative costs of an alternative cost order by suggesting mediation. And if there's no proper response, there'll be a potential cost sanction. Or if faced with the suggestion of mediation by the other party, only a reasonable refusal to engage will avoid you suffering cost sanctions. So it's not just whether the court has ordered the parties to engage in mediation. There is an obligation if one of the parties decides to suggest it. You have to engage with it at that point. Next slide, please. Last slide, I hope. Do's and don'ts. And prepare in advance. I know there's repetition. I apologize, but I can't emphasize it enough. Social landlords, please engage with all relevant departments. Very often you just want to be there. You do not want to be hanging around trying to get hold of somebody for 2 hours. You've wasted half the day just trying to get instructions from a surveyor who happens to have gone on holiday to Tenerife or whatever it might be. Get authorities to settle from all relevant personnel. So damages, works, costs, allocation of accommodation, planning. Make sure you've got access to somebody. And work out in advance your opening offer, your analysis of the case, your concessions for negotiation can be for negotiation purposes only, your risk analysis, your costs, your bottom line, your variables, and draft a position statement. Get the person who is going to be your advocate on the day to draft a position statement. Let the other side know in advance what your concerns are, what your position is, and what you think the direction of play should be. Now, that might be holding your cards to your chest. It might be being very open. That's a matter for you. But do a position statement so at least everybody knows where they're starting. And hopefully the mediator will have got the other side to do that as well. And at the mediation, I've said, have the relevant persons there, decision makers, those with knowledge, engage openly with the mediator. It is in confidence. Assist with the exploring that he or she is trying to do, and book enough time, at least a day. Apologies for repetition on that. I really can't tell you how important that is. I think that's the last slide. Ray, can you just check for me? Yeah, it is. I just note some of the bits that, so Anne Nugent has posted something on there about the Council's free internal complaints procedure. I'm very happy to talk about that, but I'm going to pass back to Sophie. And if you wanted to raise that as a question, I'd be delighted to talk that through with you.
Well, we've got that question comment from Anne. And do you want to sort of say anything? Is there a particular question that you want us to look at? I can unmute you. And we've also got a question from Sarah Lerner. But Anne, shall I just unmute you and you can ask what you'd like what Dominic to consider? Oh. So I need to know how to, Ray, can you unmute? Ask to unmute. Right, I can do that.
How's it doing? Can you hear me?
Yeah.
Yes. Oh, great. Well done.
Excellent. Great minds, Rod. So super duper quickly, I was really just answering the question, which was, where are you from? What's going on? Why are you attending? And also just to see what everybody thought about the use of an internal complaints process as an alternative to this formal mediation we've been talking about. It's cheap, it's cost effective, it has a whole lot of the advantages of what we've already been talking about this evening. And I just wanted to hear what everybody thought about that as an alternative to litigation in these types of cases, housing condition claims.
And can I ask a few questions about the scheme itself? Because obviously everybody designs their own scheme, and some authorities are ahead of others,
Yes.
as you can imagine. And I suspect if you are Bristol, you're probably a fair bit ahead of others. What does your scheme look like? And in particular, is it oral or just in writing? And how does the mediation take place?
Okay, so it's not formal mediation. It's very much a complaints handling process where we would ask the tenant to follow the complaint process, try and get their complaints addressed quickly and efficiently rather than litigating. So obviously most of us believe that what the tenant wants is a nice home, not to be living in a condition of disrepair. So we focus very much on that. And we also say, if you're still not happy at the end of the stage one, where they'll get a written response, they'll get a surveyor who goes out and tells them what they think of their complaint, what they will and won't be doing, whether they'll be doing cosmetic repairs or whether it is a formal disrepair, and then escalate to stage two, which is done through somebody separate from housing, so that we've got a certain amount of independence there. So it's
Internal,
not so much interactive as such. It's not interactive.
But so just to be clear, that tends to be written backwards and forth, and it will generally be somebody internal. But at the end of that process, I'm assuming there's the ombudsman available.
Correct.
Yeah.
Correct.
So there is a sort of, although potentially a process, there is, and again, the ombudsman tends to do things in writing, or telephone as well, but it's still an independent person at the end of it. Are you particularly hit by the claims farmers issue?
Yep.
Yeah, I mean that where they effectively try and get to court as quickly as possible without going anywhere near your complaints procedure.
Exactly.
Yeah.
Exactly.
Yeah, I mean, obviously, there's been a Court of Appeal case in which I think it's fair to say that they encouraged use of internal complaints. What they didn't say is whether or not the complaints procedure would be an ADR system that would result in a cost sanction. Having said that, there are some cases in Bristol County Court. I can't remember if it was a Bristol case or whether it was one of the housing associations, where this same issue has come up, and there have been attempts, I think, to get unless orders, unless you engage in the process. I think the weakness of, the positive of the sanction is that there's a cost sanction, but the weakness is that it's only a cost sanction. It's not the court as yet has not got to the stage where it's directing that if you don't do it, your case will come to a halt, which is something that was attempted in one of the county court cases I know. So there are limitations in terms of sanction.
Yeah.
And the second bit is that the claims farmers are not interested.
Yes.
And I have to confess that my chambers don't tend to work with claims farmers, as you can imagine. But so it's a bit difficult to know what they're doing. But from the outside, their thinking is, well, we need to get a cost order in order to avoid this, and we're not going to tell a client to go off and use the complaints procedure, because then we're never going to get any money out of it.
Correct.
So yeah, so I mean, looking at there was a county court case, I think, this year, and you could see the judge did not like that, but nevertheless effectively said, the only thing I can do is the claim has been issued, we must proceed. And that is right. As to what I haven't seen, because you don't tend to, because most of these cases do settle, what I haven't seen is what the judges are doing on costs, and whether there any punishments on costs. And I wondered whether, particularly Bristol County Court judges, I suspect, are quite used to these cases. Are judges penalising in costs as a consequence of not using that procedure?
Not seeing that specifically yet.
Yeah. So your difficulty in terms of making it ADR is the person who makes the decision. It's the fact that that is in writing and not oral, and therefore that's not a negative, but it does mean that the opportunities for sort of broader thinking are limited, because it tends to be, it's almost, how can I put this? The complaints procedure is almost being used as the way in which a landlord should be responding anyway. You know, if I'm saying I have issues about in my property, well,
Yeah.
I'm expecting a surveyor to come around and look and see what's wrong
Yes.
with it and to tell me what's wrong with it. So
Yes.
it's not that complaints procedure is not of value, which it absolutely is.
Yes.
But it's just that, is it an alternative means of ADR, or is it actually just a landlord doing what they're responsibly meant to do, namely engage with the tenant when there's a complaint being made?
Yes.
And-
I wouldn't have a problem with that argument, but
Yeah.
obviously what we're doing is we're trying to make it as cost effective for the tenants as possible. And obviously saving money on litigation when we could be ploughing it into homes.
Yeah, absolutely. What is different though between the sort of I mean, my personal view is that complaints procedure, ombudsman, fantastic, really important. But if in this, you know, if you've got beyond that, as it were, and you're looking at cases which are difficult, what you do have in a mediation is the opportunity to bring in other issues, other potential needs, other concerns, other priorities, and settle cases on that, alternative accommodation being one. Whereas on the complaints procedures, what you really get is very much, this is what I would expect. Sorry, this is what I'm expecting you to do. And then a reply saying, well, we agree to do these things, but we're not going to do these things. But you have an opportunity to go to the next stage of the complaint. In other words, it's looking at it in a very narrow way. I think rightly so, in the sense that it's engaging with the rights and duties under the tenancy agreement. But in mediation, you do have a massive opportunity to bring other factors into play and other needs and other issues. So it is a different process, and both have value in my mind.
Dominic, thanks very much. Can I just ask a couple of things? There's a follow-up question from is that Sunita? Can we request a stay in directions to enable the matter to go through the complaints process?
Yes.
Which I think the answer is yes, isn't it?
Yeah. So the CPR specifically provides for the court to stay for the purpose of negotiations.
Yeah, and also, I suppose, you know, if you're in the situation, so that's an answer to that. And of course, you could always request yourself, ask for an order for more mediation, couldn't you?
I apologize. I hadn't quite picked up on one thing. So in terms of complaints process, that's a little bit more difficult, because so you can certainly ask for a stay for the purpose of negotiating, and to that extent you might use the complaints process for it. But if you were to say, well, this is an ADR process, I think that is still very much up for debate. Apologies for.
But isn't that very much what was one, you know, part of the factual background in the Churchill case, wasn't it? So I've also got a question from Sarah Lerner, who's here. And Sarah, you've asked about mediation in public judicial review. Is there anything you want to specifically ask us to focus on? I can unmute you.
Yeah, hi. Yeah, I just really wanted to know if it is happening more, if you think it's going to happen more, and if you think it could, to what extent it's effective. Obviously, there is the complaints procedure, sort of the expectation that those are used, that's used if it's effective, but social services complaints procedures, I mean, are very limited in actually resolving care issues, in my opinion.
And Sarah, just to confirm, I forgot to mention you, but you did put it in the post. You specialise in community care and court of protection.
Yeah.
I mean, again, Dominic, do you want to start the ball rolling on that?
JR has the disadvantage of time limits.
Yeah.
So but the courts absolutely, if you talk to Martin Westgate, the courts are clear that there is a space for mediation in JR cases. But if you think, I mean, I'm a housing lawyer, so I'm naturally thinking in housing terms. Community care would be different potentially, but if there's very often applications for interim remedies, and you need to get those interim remedies quickly, whether it be housing or whatever it might be, and equally the local authority is going to want to have if they have to give accommodation, but they are pretty sure that in 3 weeks' time they're going to put out a decision that's going to mean that accommodation is no longer required to be given. They don't want to delay things as a consequence of mediation. So the time frame I find gets in the way of it. Although note what Sophie said about the fact that in a case just before trial, the judge still said no, give it a go.
Yeah.
So there is a place for it. Judges do talk about it. I haven't had an order as such where the judge has said this should be, the parties need to try mediation and explain why not if they haven't done it. Court of protection works at a slower pace. Sophie will tell me it doesn't. She's a court of protection specialist, but my experience of court of protection is that it works at a slower pace, and to that extent, I think it has potential space for it. But the difficulty with that situation is very often it's identifying what options are available in court of protection. In other words, it's not so much trying to work out which is the best option between a number of options. It's, can somebody please find what the options available are? In other words, go and find a property rather than tell me which one is the best for this particular client or whatever it might be. But in terms of the care being provided, community care considerations can often, you can imagine negotiating about the care that somebody should get, and very short decisions being made in funding decisions, and actually others coming up with creative ways of keeping the funding neutral but the benefit more positive. And that can lead to mediation that works. Sophie, I don't know if you've had any community care or perhaps
I mean, I haven't not since the changes to the CPR. So I haven't yet had an experience of a case where someone has actually, proceedings have started and one of the parties has made an application for an order directing mediation. Because of course that would be available, even if you've actually had to issue or you're facing a claim for judicial review. So you could still ask the court to direct mediation. I'm going to see if there's any more questions. Was anybody else got anything they want to ask? Or I just want to, I might just ask Jeffrey if there's anything he wants to add to anything that we've both been saying now.
No, I don't. I think what I would say, Sophie, is the common thread through all of this about giving the people an opportunity when they're in conflict to have that discussion. I was just thinking when we were talking about the complaints procedure and it being bits of paper going back and forth, and that's not engaging in people and relationships and breaking through barriers. And I think that's perhaps an important part to emphasize as well.
Okay. Thank you. Well, I can't see any more raised hands, and I can see that some people have already had to leave. So I think what we'll do is we will draw this to a close. I'd like to thank everyone very much indeed for joining us this evening, and thanks to our speakers. And I'm sure you will get a request for some feedback, and we are delighted to get feedback. We really do look at it and helps us improve any future sessions that we run. So thank you all very much indeed. Have a lovely, enjoyable rest of your evening. and hope to see you at some point in the future. Thanks, everyone. Bye-bye.